All right, everyone. Give me a thumbs up if you can hear me. Great. Awesome. Okay, well, welcome everybody. I'm going to give some time just to let everyone get into Zoom. We did have a really great turnout on registration. So I want to be mindful and allow folks to join in. You are welcome to put your video on. We are going to have some interactive polling. Please stay muted just to avoid distractions and confusion. I will get sidetracked if a squirrel runs by. So I'm asking and pleading to please stay muted so that I don't go off into la la land. We've got a lot to talk about today. This has obviously been a very important development in corporate law and kind of snuck up on most people. So before we get into the presentation, I want to just give you a little bit of background about the Corporate Transparency Act, which I'll be calling CTA so that I don't have a tongue twister the whole time. The Corporate Transparency Act was enacted in 2021. And so it was basically kind of giving everyone a heads up. And over the last several years, the federal government has been working to create the reporting platform, which was already existing for some other reporting that's done by banks in particular. And so we know that the government has put into this whole thing a lot of technology and a lot of investment for the CTA. So there was a recent ruling. We are going to talk about that today. So buckle up. I'm not going to get super deep into it, but we will talk about that ruling as well. And then also where we're going to go forward. So as we come up on, let's see, about 3 minutes in, we might have some more folks trickling in, but I'm going to go ahead and get started and be respectful to those who joined us on time. First and foremost, of course, thank you so much for joining this webinar today. Our goal as Sage Business Council is to help companies stay out of court and out of problems with the government. So we like to put on webinars such as this to keep folks informed so that you know what is required of you to avoid penalties, audit issues, lawsuits, and the like. I'm Danielle Hudson Laughlin. I am the founder of Sage Business Council, and we have been in business since 2015. So we're in our 9th year this year and going into our 10th year, which is really hard to believe. The firm has had quite a transition from doing what I would consider asset protection work initially with estate planning, business and real estate, and we really have niched into the business space over the last 5 years. It's been our primary focus. So I'm very grateful to see that we have some advisors, some of the great advisors that we refer our clients to. We also have some of our A-plus clients here, and even maybe some who have never really learned or known much about us. So it's really a great mix of folks joining us today. And I look forward to getting some feedback and questions from you. You can pop your questions into the chat function. We will have some interactive polling, as I mentioned. And if there's anything we can help you with, please feel free to private message any member of my team. You'll see that we have Brittany Collette on here. We have Valerie Gomez. And we have Marcial Torres as well. So any of those individuals can help you directly if you want to send a private message for something that may be a little more confidential or more specific to who you are. We ask that you do not share any confidential or private information in our chat. I will not be able to give legal advice in this webinar. If you would like to schedule time to talk privately, I would welcome that opportunity, and certainly we can assist you with that. But here, let's keep it very public and not super confidential and private so that we can honor your rights to protect your own information. All right, so let me get into this here presentation. What we're going to talk about today, of course, is the Corporate Transparency Act. We're going to talk about who does it apply to, what are the requirements to be compliant, how do you avoid penalties with possible criminal and civil liabilities. You want to make sure that you're not sweeping this under the rug. We will talk about the federal lawsuit that is pending. I think there's more than one, but we did have a ruling from a federal judge in Alabama just last week. We will talk about that. And then we'll talk about how do you get started with compliance. We'll talk about how we might be able to help you if you need that. And I'll give you a link to the FAQs for FinCEN, so that you can go and look up your own information if you need to go deeper than where we're going today, okay? So by the end of this webinar, you're going to be equipped with knowledge and the tools that you need to confidently navigate the CTA requirements. You're going to get peace of mind because you're going to cut through all the noise. We have seen so much. Everybody's blogging about this. It's kind of funny. I'm seeing major news outlets say that the law has been struck down as unconstitutional. That is not exactly accurate. We will talk more about that. But there's a lot of confusion, to say the least, and that is to be expected. So the goal here is to help you save your time and your resources by cutting through that noise and giving you, a corporate attorney's view on what is going on. And how it can impact and how it may impact you. Whoa, wrong way. Okay, so obviously we got to start from the top. What is the Corporate Transparency Act? The Corporate Transparency Act was enacted in 2021 during the pandemic, within the first year of President Biden's tenure. It did pass, both sides of Congress, and it has been highly lauded amongst politicians and law enforcement, because the ultimate goal of the Corporate Transparency Act is to mitigate financial crimes, specifically money laundering, drug trafficking, terrorism funding, and things of that nature. And what I would like to just sort of give you a little bit of background on and help you understand, and probably many of you who are here already sort of know this, at least at a gut level. We have seen a prolific increase in state-based entity creation over the last 20 years. Traditionally, corporations were the only way that private individuals could come together and do business in a protected, liability-protected way, as sanctioned by the government. But over time, we saw the implementation of limited liability companies. And limited liability companies created a much less stringent, less formal, cheaper, and more accessible way for folks to do business. And by and large, most small businesses are under LLC structure. Now, before we get into a whole bunch about the CTA, I also want to bring a few important facts to your attention, because the impact of the CTA is largely going to burden the smallest of the business owners out there, the smallest of the businesses that we have in America. Only about 4% of U.S. private business ever gets over $1 million in gross revenue. Now, the statistics on that, it's not abundantly clear whether they're lumping in like single asset LLCs that might hold, residential real estate or other types of single assets or not. But that's the statistic that we work with, and that's the statistic that most lenders and other business advisors basically work off of when we start talking about the sizability of small business. But under the SBA guidelines, small business can go anywhere up to about $500 million in gross revenue, and it depends a little bit on the industry that you might be in. But if we know that a small business can go anywhere from a few $100,000 a year or less up to about 500 billion, then we really are talking about a very large segment of the corporate population being small business. But if you are earning $5 million in gross revenue and some other things apply, which we will talk about, this will not impact you. Okay. So if you are above 5 million in gross receipts, I want you to stay tuned because I want you to know exactly all of the requirements that you have to meet. That's not the only requirement. But if you are above that threshold, just keep it in the back of your mind that it's possible you have an exemption. We'll talk about some exemptions here in just a few minutes. The Corporate Transparency Act is here and it's here to stay. I would be incredibly shocked to see the CTA struck down completely or repealed. We are likely to see modifications throughout this year and maybe even next and possibly into the future, just like any new law. But if we saw the ACA Obamacare Act receive significant scrutiny in the courts and still survive, I would caution anyone out there who believes that this might go away to think again. It is extraordinarily unlikely that this will go away. We've also seen a few states that have implemented transparency acts as well. And the full breadth of what this is exactly what it says. It's about transparency. Because of the prolific increase in these private companies over the years, we've also seen a prolific increase in the use of those companies as shells for criminal activity. Once money enters into a LLC or a corporation and then gets paid out of it, it gets washed. It becomes clean money. That's what money laundering is. If I go out and I take $5,000 because I sold some drugs, and then I deposit that $5,000 into my law firm as though it was legal services rendered, and then I pay that $5,000 to myself as a salary or a distribution, I have washed that money. I have cleaned that money. I have taken illegal proceeds of a drug transaction. I have put them into commerce and I have made them legitimate funds. Now, for most of us, this just seems ludicrous that we need to even be concerned about this, because that is really the focus of the law, is those sorts of criminal enterprises. And this could be drug running, it could be guns, it could be terrorism funding, you name it. But I also want us to think about things like not reporting all of the cash proceeds that we might receive for business services rendered. That is tax evasion. That is criminal activity. And that is a money laundering activity as well. If you take those proceeds that you did not report and you put them into commerce, you probably don't put them in your bank account if you're not trying to report them, but you go out and you take your $5,000 cash that you didn't tell the IRS or the state about, and you go spend it on your kid's birthday party, and maybe you go on a nice vacation. Well, that also is financial crime, right? That is also something that we need to be aware of. And if you are what we consider compliant and law-abiding as an owner, you're probably not very concerned about being exposed for financial crimes because you're following the rules. So this talk is really intended for those of you out there that are compliant and you want to stay compliant and you want to make sure that what you're doing is on the up and up. And if you have any questions about whether your existing reporting, because you're already reporting with taxes and other things, if you have any questions about whether your existing reporting is compliant or how this might impact you, if you have one piece of information with the IRS and another piece of information with the Treasury Department and FinCEN, and I'll tell you what FinCEN is in just a second, that's not what we're going to talk about here, but it is certainly something that you should be thinking about, because if you have any questions about your general compliance overall, those need to be resolved before you can really fully comply with the CTA. So just keep that in mind. There are probably some foundational things that you're going to want to do, and you're going to maybe even need to do in order to fully comply with the CTA regulations. So that being said, there is a pretty steep penalty if you do not comply. Now, it's willful failure to comply. Negligent failure to comply is not going to be actionable, but willful failure can be found where you know or should know that you should report, and you don't. So, and I'll just give a little bit of a sidebar here. Sometimes we have clients who say, "Well, I didn't know that that was the law, and it's not fair that I am punished or sanctioned for it because I didn't know about it." And unfortunately, with the regulatory state that we have now, and with government growing more than shrinking historically, there's a lot you probably don't know. In fact, I mean, there are federal regulations that are impacting all of us every single day. And even attorneys like myself who work in this space day in and day out, we couldn't even possibly know each and every and all of those regulations. There's just too many of them. So, unfortunately, ignorance of the law is no defense, and you've probably heard that before, and it applies equally to criminal action as it does civil action. And refusal to comply can expose you to these penalties that you see here: $500 a day, up to $10,000 for noncompliance. There's also possible criminal penalties, up to 2 years in jail, and you could face both of them. So it is incredibly important that when you're talking to other folks in your circles that maybe aren't attending webinars like this, or maybe people that are dismissing this as just another government overreach, or it's going to go away if the administration changes, or whatever you might be hearing out there, please be a good steward and inform your friends and your family members and your colleagues that this is not something that you want to have a couple of beers about and laugh about and move on from. This is really something that you definitely want to make sure you know exactly what you're getting into and whether or not you need to comply. These penalties are steep, as you can see. So, what are we going to talk about with respect to who does this apply to? Well, as I mentioned just a few minutes ago, there are exemptions to the CTA. And there's kind of a laundry list of exemptions. There's at least 23 different exemptions that I'm thinking of off the top of my head. Most of those exemptions have to do with entities that are already complying with other reporting. Okay, so publicly traded corporations, they are filing just endless annual reports. Banks, insurance companies, broker dealers, financial advisors, folks that are already highly regulated at the federal level, they're already reporting. They're not going to have to add on additional reporting. The primary goal of this reporting requirement is to capture all of those other entities that are not already reporting. So an exemption is very unlikely to apply to you if you are not already reporting in some other way. So you have, if you have under 5 million in gross receipts, it applies to you. I mean, 99.9% chance it applies to you. If you're over or at that threshold, stay tuned. We'll talk about that a little more. And then basically you have to report what they're calling beneficial owners. But beneficial owners is a misnomer because it's not just about ownership, it's about control. And frankly, it's really not even much about control, if you ask me. It's really about snuffing out anybody who may or may not have some existing or future interest in these entities. And I do believe that we will see some limitation on this potentially because there are some questions that remain. Let's start first with a reporting company. So corporations, obviously, LLCs, but also trusts that you file with the Secretary of State. And this one's a little confusing. So you can create a trust by private contract. If you have an estate plan with a trust involved, that is likely a private agreement that you have, and you did not report that or file anything with the Secretary of State to report that trust. However, some trusts do have to be filed at the state level. That is somewhat rare. If that applies to you, you probably would like to get a little bit more legal advice around it. Okay. I can't use this hour to go into the niche nuances of this law, but just a caveat there. If you have a trust that's been filed with the Secretary of State, then that would also potentially be included. So before we move into beneficial ownership, let's take a poll. Do you own or control, or do you think you may own or control more than one reporting company, more than one LLC, more than one corporation, one LLC? Could be a trust and maybe two LLCs. You get the idea. Yeah, we're getting some feedback here. So yeah, we've got almost everyone participating here. So I'll give you just a few more seconds in case you haven't chimed in yet, but please do. Looks like we got 100%. Okay, great. So 63% of you are saying yes. I either know or believe that I have more than one reporting entity. So we're going to talk about that in just a minute. We're going to talk about what do you do if you have more than one, okay? Because it can be a little scary, especially because a lot of times in the past, I know, and as a business attorney, we basically try to create as many entities as we can. I think I messed that up possibly with the polling there, but hopefully y'all saw that. Everybody see that? Okay, great. All right. Technology, it's helpful and also a little confusing. So we've got more than more than not that believe that they have a additional reporting for more than one entity. Let's talk about what may be exempt. That might change a little bit about what you're thinking about whether you have more than one. And then we'll talk about that beneficial ownership. So again, like I said, most of these are not going to apply to you, but these are the four more common ones that are potentially likely to apply to you. We do have some accountants that we work with. Some are CPAs, some are not. By and large, if you are a public accounting firm that's already reporting under Sarbanes-Oxley, this is not going to apply to you, again, because you're already reporting under Sarbanes-Oxley. If you're a tax-exempt entity, like a 501c3 or any other subsection under 501c of the Internal Revenue Code, you are likely to also be exempt. If you lost 501c status within the last 6 months, I guess I should say it a different way. If you lost it, you have up to 6 months to report. So some tax-exempt entities can lose tax-exempt status. If that happens, you would then be triggered to become a for-profit corporation, technically, and you would need to report, provided other exemptions did not apply to you. Also, if you own or control a trust as defined under Section 4947, A1 or A2 under the IRC, those are going to be non-exempt charitable trusts and split interest trusts. Split interest trusts have exempt and non-exempt charitable aspects to them. Again, super deep tangent I'm not going to go into. You know whether or not this might apply to you. And again, if you think that this might be you, get some legal advice that you can rely on so that if you decide not to report because you believe you're exempt, you have a legal opinion letter as to why. That is a good way to show that it wasn't willful. Okay. Uh, if you choose not to comply and you don't have anything from an attorney or maybe even an accountant, somebody that would be qualified to tell you whether this applied to you or not, um, again, you might be at risk for willful noncompliance. So just be aware of that. Now, this one is the big kicker for what the CTA is deeming these large operating entities. I think sometimes this is shocking for some of, we have some clients that are well over this $5 million threshold. And to them, it's very shocking that they are considered a large operating entity when we know that small business can go up to, $500 million a year. But hey, if you're at 5 million or more, again, only 4% get to one. So that's why this $5 million threshold exists, because it's a very small minority of operating entities that even reach that threshold. So in order to be exempt as a large operating entity, you have to satisfy all 6 of these. Okay. These are mandatory requirements. This means you employ 20 or more people. They are 20 or more full-time equivalents. Okay. If you don't know what an FTE is, again, you probably want to understand that. Most people at this level that are managing or running a company, they do know what that is. Your FTEs are within the United States. They are not offshore. You have an operating presence at a physical address within the United States. This is a gray area. Presumably, home-based businesses would be exempt would satisfy that requirement. But in my view, it's a little ambiguous what they mean by physical address. But again, I think at this point, the idea would be home base would apply because there's at least a place in America where the government could come find you, essentially, is what I think they're getting at. All right. You also filed an income tax return or information return in the last year, previous year to now, so 2023. You may not have filed it quite yet, showing the $5 million in gross receipts. And those gross receipts have to be for sales and from sources within the United States. So if you're in like e-com or anything like that and you're selling online and you don't know exactly where your patrons are coming from, it's very important that you figure out whether or not your gross receipts are going to meet this requirement. Okay. If you have questions, pop them in the chat. I'll take those at the end. We'll stay on and take those for those who want to stay tuned. But again, remember that you have to have all 6 of these, which is very critical to know in order to be exempt. And again, you would want an opinion from an accountant or an attorney that's qualified to tell you whether or not you are meeting this, would be my best advice to you. Okay, you may have an inactive entity. It is not uncommon for folks to start up an LLC or a corporation because they want to have it ready whenever they start to sell or make money. A lot of consultants do this, for example. Maybe they're going to begin a consultancy on the side as like a side hustle, and they don't know when they may make a sale. They just want to be able to receive funds when they do make a sale. If this is you, and these requirements are true, then you also may be exempt. So your inactive entity must have been in existence on or before January 1st of 2020. Critical component there. It cannot have been engaged in any active business. That means it cannot have received any money other than the $1,000 amount. Okay. So anything over $1,000 is considered the threshold for what is active business. It cannot be owned by a foreign person. If you have a member of an LLC or a member of your family who may have some kind of implicated beneficial ownership interest in this inactive entity, and that person is not a US citizen, you want to check this out. Okay. Now, I didn't go as deep as to get into exactly how they're defining foreign person, whether certain types of card holders or other lawfully present foreign persons may qualify here or not. But again, you just want to get a legal opinion if you have any question about that. You cannot have experienced a change in ownership in the last 12-month period of time. That means, oh, I took my husband off and then I put him back on, or I let my daughter take ownership because she's going to help me with my Etsy shop or whatever. It doesn't really matter. If you had any change in ownership, it would not be inactive. Again, the $1,000, you cannot either have since paid it out or received more than $1,000 in the last 12 months, and you cannot have held any type of assets, domestic or foreign. Again, some of this is a little gray, right? Well, what if I received $500? Isn't that holding a type of asset? Isn't cash an asset? Yeah, it is, right? So again, you really do want to get some opinions about this stuff if you're not sure. Because at least that can prevent willful noncompliance penalties. Okay. Assuming none of those exemptions apply to you or the various ones that we didn't talk about that are already reporting, then you likely need to comply with the CTA. So the timing for that, we're going to talk about that in just a minute. If your company was existing before January 1st of this year, you have time. Okay, you got the rest of this year. You can wait it out. You can kind of see what happens with some of these challenges and through court, et cetera. If you filed if you formed and filed your company after January 1st, on or after January 1st of 2024, you have 90 days. And that's why this webinar is taking place in March, before that 90-day compliance window. Also because we're going through annual reporting and compliance with the Secretary of State's office, as you probably know at this point. You're probably receiving emails about that. And so we're doing this webinar at this time for a very specific reason, which is to help folks that may have inadvertently created a compliance problem for themselves and they need help with it. Okay, so we'll talk about how we can help here in a little while. What is a beneficial owner? Like I said, ownership, you would think, is a clear and unambiguous term, but unfortunately, in the world of law and government and lawmaking, common parlance doesn't really seem to matter. Okay, so please don't get tripped up on the word ownership. That is only a piece of the puzzle. So if you have 25% or more ownership, that would be membership interest, units. That's typically what you're calling them in an LLC. In a corporation, there's shares or stock, stock interest. Then you are a beneficial owner. Black letter line there. In terms of the ownership, we'll talk about that in just a second, because again, you think that would mean something, but I'm going to probably shock many of you with my next slide. The second way that you would have to report is if you exercise control over the reporting entity and the reporting company. Let me use the right word. Again, we're going to talk about that in just a second, but probably some of you are going to be shocked by what that actually means. So 25% or more, quote, ownership. This is any equity interest, regardless of whether it has voting power or can be transferred. If you are a silent investor and you cannot vote on anything, but you own 25% or more, you will have to be reported. If you cannot transfer it, let's say you have an employee stock option of some kind and it's equivalent of 25% or more of a company, but you can't do anything with it right now, you still have to be reported. If you have any interest in the assets or profits of a company, profit sharing, for example, if you're getting 25% of profits from profit sharing, you have to report, even if you don't actually own 25% of that equity. Convertible interest, if you have convertible notes of any kind, safe notes, anything like that that you're holding on to, you have to report if it's equivalent of 25% or more of the outstanding equity in the company. Any future interest in the company of 25% or more, and I got to be honest with you, I don't really know exactly what they're talking about here because, of course, I'm thinking, well, what about, my husband, right? My husband can't own my law firm. That's just a regulation for law firms. He's not a lawyer, so he could not actually own my law firm. But we own some companies otherwise that he does own and he can own. And I own a company that he doesn't own any of it, and it's not a law firm. And so my estate plan gives everything to my husband and then my children. So if I have an estate plan that gives everything to my husband and then my children, which does not happen automatically, by the way, let me just dispel that myth. If you don't have an estate plan giving everything to your spouse in the state of Georgia, your spouse will only get a third. I just want to put that out there. But I digress. If you're thinking about a spouse, does a spouse have a future interest? Possibly a spouse has a current interest, okay? Because any marital asset is going to be subject to equitable set-off through divorce proceedings. And there is equitable interest that attaches during the course of the marriage. I'm not a divorce attorney, so I will give that caveat. But again, does this include spouses is a big question. And we're going to start seeing a little bit more around this, probably through litigation and or some regulatory rule changes. If you're in any contract or other agreement that grants any interest, whether it's current or future, in a reporting company and it's 25% or more, again, you would also have to be reported. If you have a put option, call, straddle, any other kind of option that's 25% or more, you also are going to have to be reported unless it's unknown to the reporting company. This is like hedge stuff. This is very rare. Most of the hedging is happening with entities that are already exempt under this statute anyway. So, but they put it in there just in case, because you can create those types of structures in private companies that are under $5 million. You can do it for pretty much any company that you create. You can have these sorts of more complex corporate structures. So if you have anything like that, just be aware that it may trigger some reporting for you as a beneficial owner of that entity. Control. Now, this one is even more frustrating. I really got to be honest here because the way most companies are managed that are going to be having to comply with this, the realities of the way small businesses is run makes this pretty broad and far-reaching. Because as you could see here, the exercise of control is a senior officer, of course, CEO, CFO, COO, a general counsel. If you have a general counsel employee of your company, they would also be considered a senior officer, a president, or, and this is the real kicker here, folks, others with similar functions. I don't really care if you call your CEO office manager, if the office manager is able to exercise control over things like contracts that are entered into, bill pay, AR, AP, hiring, firing, a lot of different control mechanisms that happen in business may trigger this. So if you don't have very clear documents and policies around this sort of thing, now is the time to get them together. Because if you have an employee, and maybe it's a key employee that's been with you for years, and you have been generous in exchange for their loyalty and great work that they've been doing for you, and you've given them uh, phantom stock vesting type of stuff, significant profit sharing, you've given them control, you've given them managerial control, um, they would become a beneficial owner that needed to report under the CTA. So you really do need to think about this. Just because they don't have these monikers behind their name doesn't mean that they're not going to be considered beneficial owners. If the individual can appoint a senior officer or a board of directors or advisors, even if they don't have 25% ownership, that's important. It's not 25% ownership and it's 25% ownership or. So if you even have somebody that's on the books of your cap structure that has 5% of your company and they get to vote on whether a senior officer or a board of director can be appointed, they're going to have to report, most likely. So again, this is really critical. If you have old documents that you got from lawyers years back, if you got documents from the online, generic depots out there, if you aren't really sure what your documents say because you got them and you never really read them and you never really got advice about what they say, you don't want records of your company that are ambiguous or wrong, because if you get audited on something like this, those records are evidence against you for willful noncompliance. So the reality is that most small businesses are not crossing all the T's and dotting all the I's. We know that. It's very difficult and it's very expensive to do it completely above board all the time. But if you have a business that you want to keep going and you want to ensure that you're not going to end up with these penalties, then it's important that you get these governance documents in order, so that you can be able to show the actual evidence. No, that person is not exercising control, because here is an employment offer letter that we gave them. Here is a statement of job description, whatever. Okay. All of that is evidence to help you out to not report certain people. So any important decision makers about financial decisions, structure of the company, governance, even if they don't own anything, if you own your business and your spouse controls whether or not you do some of these things, that presumably your spouse would need to be reported. Now, how deep are they going to go? Okay, they don't have all the resources in the world. We know that. But again, you want to get some opinion letters if you're not sure. And then really last and not least here, there's a catch-all. There's a catch-all under exercise of control, and there's a catch-all under ownership. And what does that tell me as a lawyer and a legal scholar, I guess you would say? Once the government starts putting catch-alls in there, let me please tell you that statutory construction is going to require that judges give it the plain meaning of the statute. And it's going to demonstrate a legislative intent of capturing as many people as possible, like bottom line. Okay, bottom line. So if there's anything iffy, weird, or undocumented going on, if you've had verbal conversations and agreements with people, if you took money from someone, a family member, to start your business, or maybe as a loan at some point, and you had a little winky IOU or wink, wink, you're a 25% owner of my company, you're a 50% owner of my company, you need to get some documents in writing as to that relationship, or you need to get documents in writing that say that relationship doesn't exist unless the person is going to comply with the CTA. And some people don't want to, frankly. All right. What info do you have to report for each beneficial owner? Now, I'm going to be honest with you. I have not actually done my CTA compliance for our entities. And that's for a very particular reason, which is that Not only do you have to report the name, the date of birth, the address where the person lives, and the Social Security or other government ID number, you also have to provide copies of those documents. You have to literally upload physical copies. I guess they're electronic copies of passports, excuse me, driver's license, etc. So I know I have not done my BOIR yet for any of the companies that I would need to report for, because I am hopeful at some point we will see some changes as to whether or not these document images have to be provided. Now, I don't know that that will change, frankly, but I do hope that it does, because it is that's a lot. That's a lot to hand over into a federal database. They have all that information already, so presumably uh, the State Department and the Treasury Department and the IRS can, I guess IRS is part of the Treasury, they could get this information from each other. So I don't know why we have to give it again, but that is currently what you have to give to report. There is some online reporting, and again, that's through FinCEN. FinCEN stands for the Financial Crimes Enforcement Network, and it is a bureau within the Department of the Treasury. And again, they are law enforcement. All right, let's take another poll. Are your documents up to date, reflecting proper ownership and management? Do you feel confident that what you have is what you need to be able to show who your beneficial owners are? All right, we'll give a few more minutes. Just to be clear, we're talking about your organizational documents. This could be your operating agreements for LLCs, bylaws, shareholder agreements, buy-sell agreements. It could be different stock documents or employee benefit documents. It would be your internal policies, your job offers, job descriptions, things of that nature that identify your folks. All right, we've got 100% of participation, and it looks like 75% are confident. Yes, thank you. I'm very proud of that. I am so happy that you have what you need. That is going to help you a lot. If you don't, it's okay. All right. Again, if your entity existed before January 1st, you have time to get things in order. Okay. If you need help, we're here to help you. If you aren't sure, if you want to DIY and you're not sure, we can also help you with that. We're about to launch a DIY platform. I'll talk a little bit about that at the end of this webinar. But you don't have to spend a ton of money on this sort of stuff. If you've got a small company and you don't have the resources, you can do this on your own. But you do want at least documents that have been vetted by qualified people. Okay, great. So awesome. So we've got, most people think they have more than one entity, and most people think that they have what they need. They have their documents in order. So that's really encouraging. I'm very happy to hear that. Great. So let's go to, how often do you have to report? When do you need to file your initial report? How long do you have to amend? All that sort of stuff. So like I said, if you had your entity, your reporting company before January 1st, that means December 31st or before, and this is based on the date of the articles that you receive or whatever other document you receive from the state Secretary of State office. That's the date. Okay, that's your date. If it's on or before December 31st of 2023, you have until January 1st of 2025 to comply. If you're like me and you tend to be a little more skeptical of the government and you want to wait it out a little longer, no problem. But my only caution and caveat on that is I am afraid that once we get into Q4, we're going to see prolific filing by large law firms, large accountancy firms, and things like that. Once we get more clarity around applicants and reporting for applicants and things. And just because the government website won't let you report doesn't mean that you weren't supposed to report. So I don't want to see this kind of like to the courthouse kind of idea where you're trying to race against the clock and get compliant at the very end of the year. So if you're going to do this, please set your calendars. If you don't care about handing over the images of your documents, by all means, go ahead and do it. You can report online, like I said, and it's very easy to find that information. We've got a link at the end for FAQs that also has other stuff like that. If you've formed after January 1st, as I mentioned, you're going to want to make sure that you do that within 90 days. You got to report within 90 days. And that's a little typo there. Sorry about that. As of right now, if you form after January 1st of 2025, you only have 30 days. So if you're someone who's thinking about creating a new entity or whatnot, probably you want to file that on December 30th, right? You got to give yourself the 90 days as opposed to waiting until January of next year. That's very advanced planning. It's not really going to apply to most people. Like I said, if you don't report, there is the $500 a day or up to $10,000 civil penalty, including possible jail time. The main thing to know about this is that there is a safe harbor. So if you believe that you may have inaccurately reported, there's a 90-day safe harbor for you. If you go back and amend that information, that will be deemed good faith. You will not be willfully in noncompliance. And it is also important to know that senior officers of an entity, even if they don't own the entity, you're not the owner of the company, you're just a CEO, CFO, manager, you can be held accountable for a failure to file. So this is really critical. If you have high level management in your company, you need to make sure that you are being transparent with your folks about this stuff and not hiding it from them and acting like you're the only one who has to worry about it. That will not fare well for you or for them. And so please make sure that you're being straightforward with anybody you think that could be subject to this regulation so that they're not going to have any kind of problems. Okay, let's talk a little bit about this Alabama District Court case. So yes, a federal judge in Alabama held that the CTA was unconstitutional overreach by Congress and implemented a ban on the enforcement of the CTA as against the plaintiffs in that case only. Okay. There is no national injunction on the CTA right now. It was only held unconstitutional for congressional overreach purposes, and it did contemplate how it may be able to conform to the Constitution. Again, this is just one judge. This is one judge coming out of a very conservative state. But what I want to caution is there's no ban to enforce. And what happened is that as soon as this order was entered, the Department of Treasury updated the FinCEN website to say specifically that everybody except for those named plaintiffs has to comply. Literally named out the plaintiffs. Okay, so that doesn't give you an indication about how serious they are about this thing. I don't know what could. All right, it's not a joke, and they're not joking around. They're really not. My personal view is that Congress can come into conformity with the Constitution. The main problem that I see with the CTA as it exists now, which I don't even know is really a problem, and I think on appeal might get overturned, is Congress is saying we have a right to regulate these entities because we have dominion over interstate commerce. That is a congressional power under the United States Constitution. What this judge said was, well, that's all fine and well, except you're saying they have to comply by the formation of the entity, and forming the entity in and of itself does not actually create any commercial activity. Fair enough. I think the judge is right about that. Where I think the judge might have fallen a little short, and I didn't read word for word absolutely everything in that opinion. I just unfortunately didn't have time. So I'm going to get into it this weekend with my nerdy lawyer reading. But the reality is that we just talked about that you have exemption if you have an inactive entity. If you have an inactive entity that you created after January 1st of 2020 that wouldn't necessarily qualify, why not just dissolve that thing? I mean, there's just no reason not to, rather than getting your panties in a bunch about having to report when you have nothing really to report, but you fail on a technicality. So I do think that an appellate court judge at the 11th Circuit is, I mean, the 11th Circuit is potentially going to say that he got it wrong. And there's already a carve out for that inactive status. So if you just formed it and you didn't ever do any commercial activity that would go over that threshold, it seems to me you already have a carve out for that. And therefore that, in my view, would pass constitutional muster. Possibly there's going to be an amendment at the federal level, but maybe not. So again, we'll just have to wait and see exactly what happens, but please don't fall into the trap of reading a headline and like moving this off your to-do list. Okay. Now let's take a quick poll. We've got about 4 minutes left. What's your biggest concern? 4 minutes of my presentation. I'm going to stick around for questions if anybody has them. So you can certainly stay for that. But what's your biggest concern about the CTA? And I think we have some options there on the poll. So number one, are you concerned that you might provide inaccurate information, maybe incomplete or inaccurate information? Number two, are you sure that, are you concerned you might not report on time? Maybe you don't exactly know the timing for yourself. Or are you just don't want to have to deal with it? It's just a lot to deal with. It's just another piece of red tape, honestly, right? It's just another regulation that we all have to, deal with now at this point. So what say you? What is your biggest concern about it? We got getting about 85%. We've got a few more people to chime in. Okay, great. So we've got 100% who have responded, and we've got, again, the vast majority, you're all kind of falling in the same camp here. You have more than one entity. You have the documents and information you need to show who is the beneficial owner, but you just don't want to have to deal with it. I'm right there with you. I am in your camp. But we also have a couple of folks who are concerned more about the technicalities of the law and providing accurate information and making sure that they're doing it in a timely manner. So all of these, of course, are valid concerns. There are other concerns. There are privacy concerns. I mean, there's a lot. But, unfortunately, the government already has all that information on us. And so with privacy, it's really kind of less of an issue. It's really more just like, oh, really, like another thing that we have to do. So we care about compliance. You know that. That's why we're doing this webinar. We are willing, and I say willing because I want you to understand something really important about this. As an applicant who would submit reports to FinCEN for reporting companies, I personally may have to identify myself as an applicant if your entity was formed after January 1st. If your entity was formed before January 1st, your applicant does not have to report. Because of this, we are willing to help companies that existed before January 1st just out the gate. If you had a company before January 1st, you want to get compliant, we're going to give you an offer. You can certainly work with us and we can help you with it. If you started your company after January 1st, it's more on a case-by-case basis because at that point, we are going to have some compliance requirements for you to qualify. We have a package where we are going to register your entities and we will do bulk discounts if you have multiple entities. We haven't structured and priced that out yet, but I just want you to be aware of that. We will do that for you. We will register with the federal government. We will keep you compliant. Every 90 days, we will be checking in on your compliance. Has anything changed with your ownership or control? We will make sure that you are thinking about this every quarter so that you can stay in that 90-day safe harbor window for inaccurate information. We will do annual compliance monitoring with all the new updates. Okay, so as the rules change, we will keep you informed. We will also serve as your registered agent. If you're already getting our registered agent services, we'll give you credit for that because you're paying for that service. If you're already paying for that service, we'll give you credit for that as well. And you'll have direct access to us by coming on as a reporting company that's interested in compliance. You're demonstrating to our law firm that you want to comply. And so we're going to open ourselves up to you in a way that we don't do with the public at large, which is to provide you with the ability to ask legal questions and get answers about your compliance issues. We are going to offer this to new clients if you're not a client with us, or existing clients. If you are an existing client with us, we're going to give you a discount. If you're already getting some of those registered agent services, we're going to further discount and give you some credit for that as well. This is a 3-year, up to 3-year service. And so you can choose 1 to 3 years. It's up to you. Right now, you can, with most entities, LLCs at least for sure, you can do up to 3 years of registration with the Secretary of State in Georgia for just once every 3 years. You don't have to keep doing it each year. Now, nonprofits and corporations, you still have to do annual because there's other questions that you have to answer. That being said, if you're nonprofit, you don't have to worry about the CTA. If you're a for-profit corporation, we will reapply for you every year and we'll pay those fees for you unless they change significantly. Okay. Now there are terms that are going to apply to this. So I want you to know that I'm going to give you this QR code you can scan. You can submit information that you're interested. It doesn't necessarily mean that we would be able to help you because, again, like we are putting ourselves on the line here to help companies with this. At this point, I'm not certain how I'm going to be willing to be reported as an applicant for new entities. That's still something that I and other professionals, other lawyers and accountants are extraordinarily concerned about. And the consensus amongst most of us at this point is that we're not willing to be reported because we don't want to be liable for inaccurate information. So since we wouldn't have to be reported for those entities before January 1st, we don't have the same level of liability, which is why we can give a very cost-effective offer here. This is your package for the next 3 years. So let's say they change something about the January 1st, 2025 30-day requirement. Most people that I have worked for and with, and most of my colleagues, they start with one company and then they end up with many. And that could be for various reasons. It could be for single asset protection, single asset real estate investments, for example, and various other things. So if you're just kind of starting out, you got like a small company, you really don't have much going on right now, it's very likely, especially if you're a younger person, if you're, under the age of about 50, you're probably going to get some more entities over time. And so if you get on with this one, again, it's going to give you access to reduce fees and stuff as you want to continue to stay compliant. And then after 2025, like this is just going to be, par for the course. So we're hopeful that you will do this on your own or choose to let us help you with it. Why do you want to choose us to help? Well, we are experts, right? We are following this stuff. We are a licensed attorney firm. We have errors and omissions insurance. If we do this stuff for you and we get it wrong, guess what? You're not in willful violation. Okay, if we do this for you and we get it wrong, we have insurance. We have a simplified compliance process. You're just going to give us your info and we're going to review it and scour it and get what we need from you. And then before we file it, we get you to certify it. But you just get to dump it on us and we get to present it back to you in a very neat format based on our findings. And then if we see something where we don't think you need to comply or we have more questions about things, we can dig deeper with you. If you need us to help you with getting your documents in order, we will discount fees because you will now have become a Sage Business Council client. You get different fees when you're a client than when you're not. And we're always very transparent and upfront about that pricing. This is not hourly fees. This is flat fee work and it's very defined for you. So you don't have to worry about random lawyer bills coming at you. We know that that's a big concern. And you have the dedicated support from my team and from me to make sure that things are going well. And if you have questions, you can reach out to us knowing that you have peace of mind. And I think peace of mind is really the main thing because the reality is that people like us, we do this every day. We do this for various things. We file with the government, we file with the courts. We know how to get past the roadblocks. If something comes up, all we have to do is pick up the phone. We get access to people that you don't get access to. We have networks of people to ask the right questions to. So it is, in my view, a steal of a deal to get on this program. We're only keeping this offer open until next Friday. This is a 1-week offer because we need a couple of weeks to gather info and start doing annual reporting or amendments with the state of Georgia. After March 15th, the fees are going to go up. And that's just because at that point, we know for a fact we're likely going to have to start doing some amendments at the state level and things of that nature. At that point, you may be past the 90 days for newly created entities. You may already be in non-compliance at that point. So this is why, right now we have this great offer. If you're interested in learning more, this is not obligating you to anything. That's really important to know. Scan the QR code. That's a form. It is a private form. It comes to us. It lets us know information about your company so that we can take a look at your filings and make sure that you're somebody that we can help. If you have more than one company, that's okay. We just need like the main one, right? The main company, usually there's a main one. There's a parent or the one that you're operating out of mostly. We will talk with you about that bulk discount, like I mentioned. Okay. If you have similar ownership structures, you have similar beneficial owners in multiple entities, we can create some IDs and we can fast track some of that stuff. If you have more complex structures and things like that, again, I mean, we're not creating a charity here, like the firm needs to be compensated, but we will work with you on that because where we can create those efficiencies, we absolutely will, and we are perfectly willing to pass those savings on to you. So please take a look at that. If you don't want to work with us, if you want to do this on your own, you think this is something you can do, that's okay too. This webinar is not to force you to pay us attorney's fees. This is to help you stay compliant. If you have further questions about FinCEN, scan this code on this page. This is going to take you to the FAQ page from FinCEN's website. And that's where you can go a little bit deeper. I also want to go ahead and let you know that they have a ton of resources out there. They have a bunch of kind of workflows and stuff that you can use. It's what I was using to really kind of create this presentation for you today. It is a lot going on. I mean, it's a lot. It's a huge federal regulation. But if you are super nerdy like me and you don't mind reading through that stuff, you are more than capable of doing this on your own, and you absolutely should if you feel confident that you can. And so please don't feel any pressure for us to help you. If we can help you, of course, reach out to us. I'm going to close this down. I'm going to ask Valerie, if you could just paste the link for the form from the QR code, that would be great, just in case somebody didn't get to scan it. I'm going to stop sharing my screen now, and we're going to go into some Q&A. I know there's a couple of chats here. All right, so we've got What's the web link for the CTA form? And the deadline for filing the CTA form, is this a yearly requirement? Is there a filing fee? Okay, so the web link for the CTA form, we have our form that we're doing if you want us to help you. If you don't know whether you want us to help you or not, and you want to find that link for yourself, Brittany, could you go and pull up the FinCEN reporting page and paste that into the chat? That would be helpful. The deadline is, again, thank you. The deadline, again, it's going to depend on the individual reporting company. Okay, every company is going to have a different deadline based on its formation. The deadline for our form is next Friday. Is it a yearly requirement? It is a yearly requirement if you make changes to the ownership or control of the entity. You have to report changes within 90 days. It's not like the Secretary of State. The Secretary of State is that annual state level. You do have to do that every year, and yes, unless you do a multi-year registration, which LLCs can do in Georgia. At the federal level with FinCEN, it is kind of a one and done. If nothing ever changes about your entity, you presumably would not need to update that. That's my understanding at this point. That could change. Again, that could change with regulation, but that's what we believe now. There is no filing fee for the CTA, okay? The CTA is merely a reporting mechanism. It's not a taxing mechanism. The Secretary of State fee it's not tax, but it's a taxing mechanism because it's asking you to pay for the service of receiving legal status. So with the Secretary of State's office, yes, there is a filing fee. We cover your filing fees for you. If we do it for you, we cover those filing fees as part of what you pay us. All right, and then looks like we had somebody jump off early. That's okay. I'm glad that they made it. Perfect. And it looks like that might be all the questions that we have. If you have any other questions, please chime in. I'm happy to stay on the line. You can unmute yourself if you want to ask directly. Just remember, don't share any confidential information, of course. But I'm happy to stay on for the next few minutes until 1:30 if you want to ask questions. If not, if you want to give us feedback, please do. You can feel free to drop that into the chat. If you have more questions, you can reach us. If Marcial, could you please paste our phone number there and just put it there for folks? Of course, our website as well would be helpful in case they want to get that information as well. But if there's no other questions, we will shut this thing down. Anybody else wanting to chime in here? You can raise your hand or you can just start talking. Up to you. Yes. So great question. Really good question. Thank you, Emery. If the entity has not received $1,000 or more for property, for money, anything like that, it does not have to report. If the entity, for example, we have a lot of real estate investor clients where they will create an LLC to hold a piece of real estate. Okay. That's holding an asset that would not be considered inactive. But the only way that the LLC or the trust or the corporation could hold that asset legally is if a deed has transferred the asset into it. So simply put, Sometimes folks believe that companies own things that they don't actually own because the title has not been properly transferred. Conversely, some people do not recognize that their entities own things because of titling that can happen at closing, and things of that nature. So we all do a lot of things over time, like our best choice and the moment of what we're trying to achieve. And if you have questions about your specific situation, I would say get some advice. Okay. Make sure that what you're looking at is what you think it is so that you don't inadvertently fail to comply. That would be my best advice. But the interesting part about that inactive status for the entity is that it cannot have held any assets. So even a single purpose vehicle, like a single asset real estate LLC, would have to report beneficial owners, even though it doesn't transact business. Okay, so that's where I think a lot of the pushback is coming from because it's just holding property and it's not actually in commerce. And so part of that order from the judge in Alabama, um, depending on how that litigates itself out, those might become carve outs as well. They may become exempt. As of today, that's not an exempt entity if it holds real estate by title. And that's a legal question. So I would say get some advice about it before you decide one way or another. Great question. Any other questions? Okay, got another question. Hey, Angela. I'm great. How are you? Thank you. I tend to agree. I appreciate you saying that, Angela. Just for those that may not know Angela, Angela's an accountant. She actually her company does our books. They do it for law firms. And I would say yes, I would greatly appreciate you sending anyone our way. Um, if you Valerie, could you chat the that registration form over to Angela? It looks like it is back in that chat. I'm gonna heart it. I'm gonna heart this one. That way you can see that Valerie chatted at 110 and she'll paste it. Yeah, there she goes. She pasted it just now. That's the best way because that form is they're gonna have to fill out a little bit of contact info and they're gonna tell us about their company. And then we'll be able to know if it's somebody that we can help, or if we need to maybe dig a little deeper to see if we can help. Thank you very much. I appreciate that. And we are going to have it recorded. I think it's running live now, I know on social. And we will have it recorded. And so we will have that link as well if you want to share that with anyone. If you want to tell anybody about this form or the offer that we're making, I am happy. If anybody that wasn't able to make it today, we just need that form by next Friday. And that's kind of a short window to lock in these rates just because we're going to have to prioritize those folks first. And then after we get those processed, then we'll start doing more. And at that point, I think the fee might have to go up depending on what kind of situation they have. So that's the only caveat to that. We're going to also, just to be very clear, we're going to keep kind of putting stuff out on social. So if you're not following us on the social platforms, that's a really good way to stay informed. We don't always send it on newsletters necessarily or through our client portal if you're a client, because we really are trying not to be too spammy with your email. But on social, we do. Valerie does a great job. She shares a lot of this stuff kind of frequently to make sure people get to see it. We will be doing more stuff on this. Okay. So I want to make sure that everybody knows where it's not a one and done. It's just right now we want to give an opportunity for those who really need help because they have less time than they do money, right? If you have a little bit of extra cash to send over $1,500 and get this off your to-do list because you don't know when you're going to be able to find the 2 or 3 hours or more potentially, depending on what you have going on, to figure this out, it's really a no-brainer, I think, it's for us to help you with it. So thanks for that. Anybody else? Any other questions? Yes. Valerie or Martial, can you help translate for us? Let me see. Hold on, just a second, Fabiola. Hold on. Let me send a message, okay? Um, oh, there we go. Okay, Marcel can help us. Perfect. To get an extension, is that the question? Um, exempt. Be exempt. Yes. Okay. Thank you. Okay. To be exempt. So there are a lot of different exemptions. If you have a question about whether you're exempt, we will help you determine whether you're exempt or not. So go ahead and say that part, and then I'll say something else. Marcial, can you tell her? I'm sorry, can you tell her that? Uh, yes. So exemptions, there are many of them. And so if there's a question about exemptions, we will be happy to help determine if there are exemptions that might apply. What I want to say, yeah, what I want to say broadly about that, and Marcel, you can translate this as well for Fabiola's benefit. Exemptions are going to be very rare. So I just want to make sure that everybody gives it the right level of attention to make sure they have an exemption. And if the exemption applies, it would be best, it would be a best case, best practice to have a letter from a lawyer or an accountant that says that. Um, not not for you to just think it doesn't apply to you. I do have a little concern about that for folks. Yes. So if you're asking about the large operating entity, which I'm thinking, if you're saying 6 requirements, that's what I'm thinking. Um, yes. If you in the fiscal year, depending on how you define that within your company, if that fiscal year was 5 million gross receipts, it was uh, the 5 million is qualified as US, not international receipts. You have 20 full-time employees or more, I think it's more than 20. I think it's technically 21. Um, and you have a physical location. I think there's a couple others. Yes, you would be exempt. Um, the trigger, though, is you also had to have filed the previous tax year showing 5 million in receipts. So I'll let you tell her that, and then I'll say something else, Marcial. Okay. Okay, good. Yeah. So one thing with that potentially is, well, if I start operating this year and I go over $5 million this year, am I exempt? Well, technically no, because you didn't file last year showing that you had over 5 million in gross receipts. So I think the idea there is that you do report at least one time in some way. I think the idea is that every reporting company will report to the federal government either under the CTA or some other reporting mechanism. And so until you triggered one of the other reporting, you would report that first year of 5 million or more because you didn't report the year before for 5 million or more. Okay, so yeah, you're welcome. Thank you, Fabiola, for bringing up some very important questions. Um, there's still a lot we don't know. And as much as Congress and lawmakers try to be clear with law, um, for any of you out there who are clients with our firm, you already know this. It's just not that clear most of the time. But more importantly, um, while this is frustrating and it's another, hoop that we have to jump through and things like that, um, the purpose of this act is critically important. We, as a nation, we have to start reining in some of the unfortunate byproducts of our free nation, and because we have so much freedom here, it is a place where people with not good intentions uh, want to be because the rules are looser than they are in other places around the world. So America seems, in my view, to be recognizing that while we do want to preserve freedom, we also want to ensure that our laws are not being used to harm people. So that to me is really the underlying purpose behind this act. And it is unfortunate that law abiding folks have to um, do these sorts of things because of the bad acts of others. Yes, that is very unfortunate. But, together by being compliant, sharing information, helping each other out, hopefully we can start getting some of those bad actors out of the economy so that there's more market share for the people that want to follow the rules. So that's what we like to do here at Sage, is help good business stay in business and put bad business out of business. It's really a great and noble mission that we have. So I hope this has been very informative for you. I am, of course, going to be staying very well informed about this. We remain committed to helping you understand your compliance requirements. So please don't hesitate to reach out to us. Thanks for staying on and listening to some really boring information. I really do hope you learned a lot today, and we'll be doing some more webinars soon. So please stay tuned and get on our newsletter if you're not on that. Get on social, whatever you prefer, email or social. But that's how you'll stay up to date with the new stuff that we're going to share. Okay. So with that, I will say goodbye. I want to say thank you to my great team for helping. You guys are awesome. Thank you all very much. We will see you all again very soon. Bye for now.